Out here on Kirk's Law Corner, August 27th, 2026. And another month is gone. How about that? Let's see over here. There we go. Diesel D's, good to see you, brother. Let's see. There we go. Wendy, good to see you. Marco Patterson. Jill Z. No, Wendy, I hadn't seen that video about the tornadoes out there in Illinois. Good old crazy weather out there, huh? It's definitely been a crazy year for weather here. I mean, I'm looking at snow on the hilltops, or mountaintops over there right now. It's been back to kind of being a little chilly, but it's trying to warm up. Woke up to frosty ground and everything was frosted this morning. That's not good. Not this late in April. Not when, fruit trees are budding and all that stuff. Frost. Every tree that got frosted and any plants, not good. May have another year of no apples from the apple tree like we did last year. Oh. Okay, Wendy. Let's see, who else we got over here? Prayer Warrior, good to see you. Michael Casper, good to see you. Alaska. I wonder who the Alaska is there. Dreaming Deer, JPC5. Tiger, good to see you. Is that Michelle or Michael? Michelle. And Rob Banks. You two are new-ish. Well, apples usually come later, but yeah. And let's see what we got here. Anybody over here on? Thank you, Wendy, for checking out there. Ross Marley, good to see you. Mark, all right, you're here on time, late like I am. Cold in Spokane, huh? Yeah, well, you're up north, so. But it was odd down in Yuma, Arizona. It was hot. It was a hot one this winter. And it was a warm one here in Idaho. We didn't get our super cold freeze out weather like we usually do. I mean, there's at least a couple of days in like January-ish, either usually early January, right after Christmas, it'll get sometimes down to 0. A lot of times in the single digits for at least a week, sometimes 2 weeks. But usually through the winter we have we're down into the teens all through January and late December, January, and parts of February. We're usually in the teens. We didn't, not very much. You have cold weather 7 months out of the year now in Spokane. So let's see, what else we got here? Anybody? Oh, there they are. It wasn't showing them at first. John from Sonora, California. Good to see you, John. Pamela Johnson, Wendy, of course. Thank you, thank you. Genevieve, I think. Congratulations to you as District County Commissioner here in Tennessee, September 1st. And X, thank you, Wendy, out there on X. Chad says, Nick, good to see you. S. Marie. Yep, good to see you. Deplorable, 1957. Real weekend wear on BitChute. Yep. I guess that video is finally going viral. Deplorable on YouTube out there. Guess that video with me speaking at the legislature related to the COVID stuff and the shutdowns and all that, and I was accusing the governor of treason. This was all unlawful, and then our rights, they don't have any authority over our rights. And I demanded an investigation, but they didn't do it. James, good to see you out there on YouTube. What else we got? And Bobby Hall. So, where's Karen? Mark, your turn to check on Karen. And oh wait, there's more. Okay, over here on Telegram, you got Liberty and Justice, Ralph K. Okay, good to see you, brother. Radar Star, Gail Hendrick, the Palindrome. Good to see you, Kathy Watson. Good to see you, dear. Hope things are going well for you. I don't see Jacqueline. Missing. That's okay, Kathy. I run a little bit behind tonight myself, too. Can I drop a link to that? Man, I don't even know where it's at right now. I know that I posted it on Telegram a long time ago, and somebody stole it off my Telegram and started spreading it around out there. It's only been in the last, maybe 2 years. But it seems like it's lately just, I don't know, just all of a sudden. But see, this goes right back to, people are waking up. I'm seeing more and more people, like even here tonight. I mean, there's like at least 3 people here tonight that I've never seen your names before watching live. So, and welcome to the new ones. If you're just finding me, you're just waking up, whatever. Right, Mark? Jax is always checking in on you. But she must be tied up or something. Awesome, Genevieve. You're learned quite a bit from me and others, which is good that you're learning, right? That's what we're here for. And glad that you've learned and gained the knowledge for that stuff. So, and thank you for your comment about thank you for my service and shared research and applications of law as they were written and intended. That's the key. What was the legislative intent? Like, what was the intent of creating the Constitution? Huh. Who created the Constitution? I've seen you and we've spoken on the phone. From Tennessee. Huh. Oh, I'm trying to remember who I've talked to from Tennessee. And I had to have met you when I was out there with John Gentry? Well, hang in there, Windy Windy. Sorry, had to. Hold on tight. It'll blow through, right? Now you got me curious who you are and walking tall. Man, I don't know. Where did we meet? When did we meet? Just go to sleep, Windy. There you go. Sleep through the storm, right? And be calm about it, right? There's nothing to be worried about it. Do not fear. Oh, thanks, James, for shadow banning me on YouTube. Is that having issues over there? Oh, Munson58, good to see you. Still no Jacqueline. Jennifer. Hmm. Yeah, I see that you're on YouTube. Did you ever go by Guinevere? Whoa. Yeah, Shelly. I don't know. You still have my contact info, Shelly? If you do, send me an email. We can talk about what you just posted there and some other catch up on some old times there, and or I should say the new times. Well, of course, fruit of the poisonous tree. The judges always rule against us, right? It happens all the time because I try to explain that like this: that the first court we go into is the de facto kangaroo court. And what I mean by kangaroo court is they don't recognize rights. But the trial court, right, they, by evil design, right, to deny everything and make us fight. You have to fight for your rights. And I've learned that, ooh, wait a minute. Hi, Laura Brown. Good to see you. Thank you. And Joanne Sanguinetti. Sorry, I butchered that one. Blackburn. Good to see you. Thanks for following for years. Yeah, they want us to fight in these corrupt courts, and they're the gatekeepers, right? And one of the things that I've learned is about doing these constitutional challenges. One, in the very beginning of the case, motion to suppress creates the record for on appeal. Right? The judges denies, but I also recently learned, I didn't realize that we could do interlocutory appeals on criminal cases. We can. So that's a new one, which is kind of the stuff that talk about over on Wednesday night workshop. So if anybody, first I want to thank all of my current supporters and followers over there on Patreon. If you want to get in on the Wednesday night workshop there, that's tier 3. If you're looking for one-on-one time with me, that's tier 4. Tier 1, tier 2, that's $5, $10 a month. It's just set up for basic donations to help support what I do right here, right now. So if you're, as well, now I have the Buy Me Coffee. So that links, all those links are in there in the description below. If you'd like to help support me, donate towards the cause here of educating mankind, what our rights are, where they come from, and how to effectively claim, exercise, and defend them following due process of law. There's Karen. We were talking about you. Were your ears ringing? Ears burning? Oh, absolutely. Fruit of the poisonous tree comment. I just get about hammered, right? I get it. Tired of going to jail because they just make shit up as they go. Oh boy, do they ever. They will falsify evidence, documents. I mean, I just busted them in this last case. They tried to submit in evidence the night before trial. Oh, look here, yeah, we got this from the blah, 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 blah. And I'm like, this isn't even in proper form. This is a fraudulent document. So, the night before trial, you want to try to come up with some evidence? I already did my request for discovery. Discovery's over long before the day before trial. Oh, well, we have a continuing duty. Yeah, for exculpatory evidence. But again, fruit of the poisonous tree, appeal, right? And then there's the other thing is the motion to stay the execution of the sentence, so they can't throw you in jail pending the outcome of the appeal. But you have to set things up in the very beginning. That's the key. You have to, because on appeal, they're only looking for errors. That's it. Errors by the lower court. Technically speaking, it's supposed to be a writ of review, to review the record for errors. Right, James? Fraud is mainstays. Oh, absolutely. You get a little bit of smarts about you and you start learning this stuff and knowing what they're doing is wrong and start calling it out. That's when the fraud really comes out. They pull all sorts of stuff. I mean, I've even gone so far as had them change the code, the verbiage, word in there because something that I used, or something like big one was Bob Coy when he did the UCC1 filing under the code, Idaho code, for common law stuff, and he did that. They tried to bust him for felony filing fraudulent documents, basically, and he went to trial, convinced the jury about it, and the jury said, no, you're not guilty, unanimous not guilty. So, oh yeah, I'm very well aware of the fraud stuff. Bredoviev, I think that's actually how it's actually pronounced. Seems like uniforms and robe wearers want to criminalize everyone so that it will make their kangaroos jump upon command, right? If you hold a position of authority, you have diplomatic immunity. Well, to a certain extent, right? They want to claim that you can't outright sue them, but if you can prove that they're violating your rights, but see, it really should be done in the criminal case. But to go back to your first part of your comment is, yeah, these are bills of attainder, bills of pains and penalties. It's all about enslaving mankind. They want to control our every aspect of life, and all of this so-called legislation is really just a bunch of rulemaking under Administrative Procedures Act by the executive branch. So they can make money. It's revenue, which is a form of human trafficking, debt slaves, and peonage. And that's a good one too. Encourage everyone to file everything fraudulent or wasteful with the Inspector General and get the ball rolling with discovery and presentation. Imagine that. Either Inspector General or the Attorney General of your state, or even the federal District Deputy Attorney General. Absolutely, Amundsen. Can maxims of law be used in constitutional challenges? Absolutely. Because what are maxims of law? Those are fundamental principles of law, a rule of law. Ooh, they don't want us to know that stuff. Yes, yes, absolutely. You know, like I use the one that to know a thing and to be bound to know it are regarded in law as equivalent. When the officer was on the stand in the previous case and started asking him questions about the Fourth Amendment, blah 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 blah, and the prosecutors, but objection, and the judge tried to say, well, you're supposed to ask me questions of law, and I'm like, this isn't a question of law. And I said, the maxim of law here is to know a thing and to be bound to know it are regarded in law as equivalent. And the judge was like, I'll allow it. And I did it to him 3 times. Three objections in a row. And it's like, no. This isn't a constitutional challenge as a question of law. This is a question of whether or not he knows the law. And yeah, he looked pretty stupid up there on the stand, which later I have found that that's not actually the best practice. I know it was kind of felt good to me to make him look like an idiot on the stand. But I have learned, again, something new, right? Learning something new every day. But, you know, just get the facts out of them. That's the key. And making sure that you're creating your record. You get 4 different affidavits of probable cause. They change it every time I see them. Oh, well, make sure that you save them as evidence. Genevieve. Okay, gotcha. I'm just now looking over on the comments for over here. The thing is something about those for affidavits for probable cause. Probable cause, great if you've got probable cause to go get a warrant. The Fourth Amendment says no warrant shall issue but upon probable cause. If they claim that they had probable cause, that's great. Did they go get a warrant first? Because if they didn't go get a warrant first, they violated the Fourth Amendment. This is something I'm banging out right now, is the fact that they're making unlawful arrests. And it, you know, now it's been almost 4 months now, but I found the State versus Clark case, Idaho, 2019. And there was a gentleman, Clark, who was challenging this, but they're saying the merits of the case are that it was after the misdemeanor was created that they can't make an arrest. But if you look at the case, what they found was the history of law, right? And again, this is something new, right? They're going back to the history of the right. And they don't care about any statutes or case law, because that's not law. Uh-oh. So in the State versus Clark case, they said, oh, well, the rule of law is, or the rule is, that you cannot, without a warrant, you cannot make an arrest for a misdemeanor. And this is the Stephan versus Stephan. The guy's name is Stephan, on the history of the criminal law of England. That was the second source they cited. The first source was Blackstone's Commentaries on the Law of England, Book 4, Section 289, which is exactly what I put in my memorandum of law in support of my motion to suppress and my motion to dismiss. Like I said, I didn't find State versus Clark until, 4 months ago. That was clear back a year ago now, when I made that motion and put that in there. But I find it quite odd that That's the number one thing they went to. In fact, let me pull that up, maybe. Oh, you know, I'm gonna have to plug it in because I don't have it plugged in. USB. Let me see. Should be in here. No, it is not. I thought I put it in here in my case file folder. Where are you? Here's that State versus Clark case. This is in the August of 2018 term, filed June 12th, 2019. Now this was a guy who was messing with this gal out on the beach, and she left, and then she called the cops. The cops went and found him, arrested him, and then charged him with felony possession of controlled substance. He had possession of methamphetamine, misdemeanor possession of marijuana, misdemeanor possession of paraphernalia, and misdemeanor battery. The latter being the charge that resulted in his arrest. Clark pursued his motion to suppress. He alleged there was neither a constitutional nor a statutory basis upon which he could have been arrested. So as a result, his arrest had been unlawful. If his arrest were unlawful, the contraband obtained... Contraband? I thought we were free. We should be able to have in our pockets whatever we want to have in our pockets, whether it's methamphetamine or not, whether it's marijuana or not, whether somebody considers it paraphernalia or not. It doesn't matter what it is. Drugs are bad, okay? But doesn't matter. Free will. And there's no injured party. So what they're saying here is, it violates the Fourth Amendment and the Idaho Constitution, Article 1, Section 17. Okay? And so, here we go. Standard of review. They're reviewing the record, right? See, like mine is they're talking about here, in reviewing a district court order granting or denying a motion to suppress evidence, the standard of review is bifurcated. The court will accept the trial court's findings of fact unless they are clearly erroneous. So like mine, we're gonna have fun in mine because the judge says, Kirk was arrested for driving without privileges. That's a lie. Didn't discover the alleged driving without privileges until after the arrest, not before. I was arrested for not having plates on my car, and that's what I put in my affidavit. So They're gonna have. We're gonna have fun with that. And then, however, this court freely reviews the trial court's application of constitutional principles in light of the facts found. Fruit of the poisonous tree is a legal metaphor, meaning that evidence is inadmissible in court if the evidence was derived from evidence that was illegally obtained. And what's your name, Fruit of the poisonous tree over there? In other words, if the source of the evidence, the tree, is poisonous, so is the fruit. So where I'm going is, he never had the lawful authority to make the arrest to stop me because I didn't have plates on my car, because it's not even a crime. I was going that route. Didn't even, like I said, I didn't even discover this. But then I discovered Blackstone. I'm like, well, wait a minute. No. Without a warrant, you're only allowed to make an arrest for a felony or breaches of the peace. And then I found this. What do they say? Blah, 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 blah. Man. Okay. Bear with me, folks. I have to go pee really bad. Okay. So, again, back to the State versus Clark case here. And what are they saying here? Recently in Green, this court interpreted Idaho Code section da-da-da-da. See, they're going by the code 6 and 7 and explain their relationship to Article 1, Section 17 of the Idaho Constitution, because these subsequently enacted arrest standards did not exist at the time the Idaho Constitution was adopted. And because they were not incorporated by constitutional amendment, they cannot be considered part of the constitutional standard for what constitutes a reasonable seizure of the person. Oh, reasonable? Remember that articulable and reasonable suspicion? Huh. Well, let's see. What do they have to say here? As a corollary, Green held, because the constitutional guarantee against unreasonable seizure of the person includes an arrest, the Idaho Constitution incorporated the principles regarding arrest in the Idaho statutory and common law in 1890 when the Constitution was adopted. What's statutory law? Uh-oh. However, we conclude that this statement in Green is overbroad. Green should stand for the principle that pre-existing statutes and the common law may be used to help inform our interpretation of the Idaho Constitution, but they are not the embodiment of, nor are they incorporated within the Constitution. Yeah, the common law is, because the common law was laid down before the Constitution. That's the key everybody is missing here. The common law is supposed to be our fundamental law, not Roman civil law, the code. But that's the trickery. That's the trickery they're trying to save right here. And that's why they're saying, well, Green is just overbroad. No, in Green, they actually nailed it. I mean, it's right there. They cannot be considered part of the constitutional standard for what constitutes a reasonable seizure of the person. I don't care what the statute says. Statutes are not law. It's policy, at best. So let's go read this some more here, because you're gonna love this one over here, Fruit of the Poisonous Tree over there. And anybody else, you know, this is what I've got on challenge, right? And what's going on appeal here is that they're making unlawful arrests when they do a traffic stop. Oh yeah, that's an unlawful arrest. That's a bill of attainder and bill of pains and penalties. It's shit made up. Here we go. When construing the Idaho Constitution, the primary object in construing, since when do we construe and interpret the Constitution? The primary object is to determine the intent of the framers. It's written in plain English. The best resource is the compilation of the proceedings and debates of the Constitutional Convention of Idaho of 1899. No, that's not actually the best source. Although in the framers at the time, the problem is the common law pre-exists the constitutions. So what is the common law? Now they say, unfortunately, Article 1, Section 17 was adopted without debate. In the absence of the words of the framers, rights guaranteed by the state constitution are examined in light of practices at common law and the statutes of Idaho when our constitution was adopted and approved. But no, I don't give a rat's ass what your statute says. Statutes in derogation of the common law must be in strict compliance with the common law. I wonder why that maxim of law is the way it is. Uh-oh. Kirk, you didn't go to law school. Where'd you get your law degree? The law is supposed to be written in plain English so that the average man can read it and comprehend it. We don't have to go to law school. In fact, we don't have to go to school for anything. Are we that much of an imbecile that we can't learn anything outside of going to school? School is nothing but brainwashing and indoctrination. The real school, School of Hard Knocks, and learning it for yourself. That's the only safe way to do anything, learning anything in today's time, is doing your own independent research and thinking for yourself. Very, very, very good question, Diesel D's. Isn't the Constitution, by definition, a statute since it was created by man and doesn't come from God? Yes and no. It's a higher form of a statute. But the key part of a constitution is it's the instrument of government. You know, when we talk about, mind control, government is mind control. Yes, because it's a figment of our imagination. And we take those figments of our imagination and we put it down on paper and we create government. Now this is this brings up, well then, only the sovereign has the power to create. So that means we, the people, created government, the Constitution. Therefore, the people are the sovereign. Right? We're not a monarchy here. We're not an aristocracy. We're not a democracy. We're a confederacy. Absolutely, Mark. Great one. Constitution revisions stand on a higher plane than statutes and are mandatory. Mason's Manual for the Legislature, page 17, section 7, number 1. Thank you, Mark, for that citation. But back to the Constitution itself. Yes, even American Jurisprudence, volume 16, Constitutional Law, section 2, specifically states that constitutions are merely just a higher form of statutory law, because it is man-made. But the key difference is, one is made by the people, the sovereign. The other, statutes, are created by the General Assembly, the legislative branch. So, and it's only supposed to be based on certain subjects that are delegated in the Constitution. So, oh, I'm missing my comments over here. It's not scrolling down. Good to see you. Fix it fast, Jameskin. Oh, yeah. Well, James, I encourage people to learn what the word traffic means. And I have discovered from not only Joseph Story in his commentaries on the Constitution, Joseph Story there, that commerce undoubtedly is traffic. Traffic is not commerce. Commerce is traffic. Commerce is the subject. Traffic is the transportation of persons or property. Oh, in commerce. So any foreign or interstate or intra-state commerce is what traffic is. So, that's the other half of my case, or a third of it, of my claim there, that this is all unlawful. I did a judicial notice on the term traffic, on the judicial notice on commerce, judicial notice on the laws of nature, my rights. my God-given rights. It's not the right to travel, it's the right of personal liberty. That's the real right. So, again, learning your rights will help people understand that. Ram Red Bud, good to see you. Natural locker, yeah, right, right, James. Nature spoke there. Okay, so let's go back over here to our State versus Clark, because this is so good. We got to go back to what the framers were talking about at the time. But examined in light of the practices at common law and the statutes of Idaho when our Constitution was adopted and approved by the citizens of Idaho. This court has long taken this approach in interpreting our state. Interpreting? You are not to be interpreting the Constitution. You're bound to support it. This is a misnomer. You have no authority to interpret the Constitution. You're not the writer of the Constitution. You're bound to support it, not interpret it. That's telling us what it says. No, we tell you what it says. We must now determine the meaning of the language used in Article 6, Clause 3 of the Idaho Constitution. That's what they're talking about in that case. In the light of conditions as they existed at the time the Constitutional Convention was in session in July of 1889. But that's the thing. When we're talking about what the common law is, the common law pre-exists the Constitution. And the common law doesn't change. We have explained the significance of case law and statutes existing in 1890 as follows. Because many of the delegates to the Constitutional Convention were outstanding lawyers in their day, we generally presume that they knew and acted on such prior and contemporaneous interpretations of constitutional words which they used. Except these are not constitutional words. This is common law words. Thus, a review, but they get it right here. Thus, a review of the common law is in order. What is the first thing they cite? Blackstone. The constable hath a great original inherent authority with regard to arrests. He may, without warrant, arrest anyone for a breach of the peace. Here's the second part. And carry him before a justice of the peace. And, in case of felony, actually committed or a dangerous wounding whereby felony is like to ensue, he may upon probable suspicion arrest the felon. What is it? 4W. William Blackstone, Commentaries, Section 289. Well, I'll be damned. That's exactly what I cited in my memorandum of law. Boy, howdy. This is going to be a good one on review. But it gets better. By 1883, a scholar of the common law wrote, there were, and indeed still are, a good many differences of the considerable importance to the procedure relating to the prosecution of felonies and misdemeanors respectively. The most important are that, and again, notice that this is in italics, as a rule, that's the common law rule of law, rule of the common law. As a rule, a person cannot be arrested for a misdemeanor without a warrant. What? What? That's it. That's what's in italics. That is the rule. Take a picture, a screenshot, whatever you need to do right here, right now. Because that's it. That a person committed for trial for a misdemeanor is entitled to be bailed, speaking generally, whereas a person accused of felony is not, which is BS. And then on trial for felony prisoner is entitled to 20, blah, 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 blah. Stephen, History of the Criminal Law of England, Section 193. Now, what did they say here? The common law, as it developed throughout the United States prior to 1889, appears to have been unanimous in agreement with that articulated above. Appears to have been unanimous in agreement with that articulated above. So every single arrest that they're making out there without a warrant that is not a felony and that is not a breach of the peace, which are assaults and batteries. Oh, gee. A victim? Uh-oh, uh-oh. Wow. Does everybody get the bigger picture here? It's much worse than we thought. Well, we got probable cause to make an arrest because the statute says that's a crime. Well, unfortunately for them, the common law says no. The Fourth Amendment says no. Article 1, Section 17, the Idaho Declaration of Rights, the common law being laid down, says no. You cannot make an arrest without a warrant except for a felony or a breach of the peace. That's the law, and why it says the right of the people to be secure in their persons, papers, houses, and effects from unreasonable searches and seizures, right? And no warrant shall issue but upon probable cause supported by oath or affirmation. No warrant shall issue without probable cause. Oh, crap. That means they're supposed to go to the court with their probable cause, take the stand, be sworn in under oath, testify under oath, and then reduced to writings, signed, sworn, and subscribed. That's how due process of law works. Uh-oh. Yep. This is exactly what I have done in my paperwork. What's on challenge right now? Right? There's the other one, Art. As this, when we get into the Bill of Rights, the Fifth Amendment, right? No person shall be held for an infamous or it's a capital or otherwise infamous crime must be done by a grand jury. Uh-oh. And now I found it in the they want to talk about the statutes, the Criminal Practice Act of 1864. That's how that's supposed to be done. And it says all felonies and misdemeanors are to be prosecuted by a grand jury. You have to have a grand jury indictment. That is what protects us from corrupt government, from maladministration, from usurpations of power. So, They're in unanimous agreement with that articulated above. And then what else they say? Oh, look, we go to Massachusetts. Well, that's not Idaho. Peace officers may, without a warrant, arrest a party whom they have reasonable ground to suspect. Reasonable, that's that articulable, reasonable suspicion that you have committed. It's not a crime, it's a felony. But a peace officer cannot arrest one without a warrant who is suspected of having committed a crime, not a felony. Thanks for all these case citations, State of Idaho, Supreme Court. Why didn't you change it then? Lucy, somebody's got some explaining to do. You found the history of the law, of the right, the common law, in 2019, and you didn't shut unlawful arrests down. It's all right here. That officers have a right to warrantless arrest for breaches of the peace committed in their presence is conceded by all. It is equally clear that they cannot arrest for a past offense, not a felony, upon information or suspicion thereof. It doesn't matter. A peace officer has no common law power to arrest without a warrant on mere suspicion of a misdemeanor, although he may do so for a breach of the peace or misdemeanor less than a felony committed in his presence. Oh, what is that? What case would that be? No. That is incorrect. That is case law. That's not the law. See, the difference is this is citing law. This is an interpretation, some judicial opinion. But then you say right here, you go right back into here. No arrest can be made without a warrant except in cases of felony or in cases of breaches of the peace committed in the presence of the arresting officer. Overruled on other grounds, so that doesn't matter. Any law which would place the keeping and safe conduct of another in the hands of even a conservator of the peace, unless for some breach of the peace committed in his presence or upon suspicion of felony, would be most oppressive and unjust and destroy all the rights which our Constitution guarantees. That's Blackstone's. That's Blackstone's commentary on the law of England. And I cited that in my memorandum of law. So what do they say? Our research has failed to uncover any decision from a sister state prior to our state's Constitutional Convention which held that a peace officer could make a warrantless arrest for an offense committed outside his presence. Because that's what this case was about. The earliest such case that we have been able to locate was decided in 1895. That case, Baltimore, presented a unique set of facts. There the plaintiff sued the railway, false imprisonment, blah, 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 blah. I'm not going to go there. I've already gone there before. But see, the thing is they have failed to uncover any decision. And see, this is what the judge is saying. Oh, well, that's not the merits of the case. Okay, well, I guess in the merits of my case is, can you make an arrest without a warrant? And if so, for what? Let's get it clarified back to the common law, the way it's supposed to be, and set the people free again. Free us from tyranny and oppression. You know, so this is what I'm working on, folks. And, you know, if you want to help support me in my endeavor here to shut this all down for everybody, you know, make your donations over there. I greatly appreciate it. Because I get that not everybody can do this. So help support somebody who can. And I'm doing this without a member of the bar because they're not going to do it. They obviously had the opportunity right here in 2009 to set the record straight when they found the law, the history of the right. And if they're stating here that the common law, as it developed throughout the United States, right, appears to have been unanimous in agreement with that articulated above. That's what they found. That's what the common law is. That's the law. This is the rule of law. There's no debate here at all. There's no argument that could be made to say, we can make an arrest without a warrant for this type of misdemeanor over here, or, you know, it's a traffic stop. It's still an arrest of our personal liberty. You're depriving us of our liberty. That is what constitutes an arrest. Otherwise, it is a false imprisonment. Well, that's good, Mark. Washington State, no more mandatory bar members anymore. Good. I know, it's coming, folks. The bar is going away. We're getting there. Take some time, but it is happening, folks. The bar is going away. Yeah, Genevieve, exactly. But I'll tell you right now, even in the Marine Corps, and them teaching us the Constitution and the Geneva Convention, it was more angled at the at war type stuff. But you would think that they would have taught us that cannot make an arrest without a warrant except for a felony or breaches of the peace. But not really, because again, Marine Corps, if we're talking about going into battle, we're not there to make an arrest. Not really. Shoot to kill, especially Marines. You know, one shot, one kill. Make your shots count. That's the way we were taught in the Marine Corps. One shot, one kill. Take your time. Make it count. Other than with the Geneva Convention and stuff about dealing with those who may surrender. Other than that, unless they're surrendering, we shoot to kill. That's the truth. That is what a Marine is trained to do. Right, Mark? Count your rounds. I have no idea about Pennsylvania versus Mims. Oh man, Bougie Boondocker. I hope I said that right. So, you know, the State versus Clark case, and I'll go back up to the top here so people can see the case. Okay. In the Supreme Court of the State of Idaho, docket number 45062, State of Idaho versus Peter O'Donnell Clark. And see, that's the thing is, why don't they put down the real case number? They give it a docket number, but you should be able to find it pretty easy from there. So, It's in the PDF. 165 Idaho 393, 446 P3D, page 3rd edition, 451. But this is the case. And yes, absolutely, you could use this case in your state. It doesn't have to be just Idaho. Because what are they talking about? They're talking about the Fourth Amendment, our right to be free. This isn't up for debate. This is the law. This is the common law. Whoa, really? Just got a comment over here on Telegram from TLM 592. In southeast Missouri, in the courtroom, the bar that separates the judge from the people has been totally removed. Huh. Yeah. Yeah, that's Chris's name there, Karen. Spelled correctly. That is correct. Freedom Fighter, good to see you. Say what again? Say what again? Say what again? I've said a lot of things. But this is the history of the right, the Fourth Amendment, the right of the people to be secure. This is the law. That part? Oh, what was totally removed? Okay. In southeast Missouri, the bar that separates the judge from the people in the courtroom has been totally removed. So that means it's open. No more bar in that courtroom. But yeah, that's my first time hearing that one. But Art, as you can see from the State versus Clark case, this is the history. This is a review of the common law is in order. This is the common law. And there is the rule of law. That as a rule from the common law, the person cannot be arrested for a misdemeanor without a warrant. The only exception is for breaches of the peace. I mean, this is clear, plain language, but this is the rule of law. I'm trying to get that all on one screen. I think that's the best I can do right now. So for those that like to screenshot that, I haven't. I've been pretty busy. Um, Very interesting about Southern Poverty Law Center being criminally indicted. Oh yeah, and I forgot I was going to talk about the attempted shooter there at uh, the dinner party there with Trump. Um, Another liberal nut job. But um, you know, I read through the so-called um, the email note that he wrote supposedly to his friends and family. And I'm going to tell you right now, somebody else wrote that. They don't. That's not something that you write before something like that. Correspondence dinner. Thank you, Jameskin. And yeah, it's just well, I don't know if they actually called it a manifesto on this one, but it was a copy and a paste, so I didn't actually get to see the actual written email. But um, there's a situation of somebody who's been brainwashed and indoctrinated, right? That oh well, uh, I just can't stand these pedophile racists. I mean, that verbiage right there is the standard MO out there for all these liberal nut jobs. You know, racist, bigots, all this stuff, and it's like, no, how is that racist? And it's funny on the 60 Minutes interview, that woman was asking about, gosh, yeah, I've only looked at this stuff once, so um, for those of you who seem to think I have this uh, photographic memory, no, I have to read it a few times. But in this instance, I'm not remembering exactly what was said because, like I said, I've only seen it once. I've been pretty busy, so. But and I only saw the one little video clip there with Trump and that. Whatever that phrase was that she quoted in there about these people, and Trump's like, I was exonerated. I'm not a pedophile. I'm not any of that stuff involved in the Epstein stuff. Notice he chose his words very carefully there. But just another play. Somebody trying to ruin the night for everybody. But Trump actually wanted to stay, but it's our policy, it's our protocol. Well, Art, your comment here is that all courthouses using search and seizure devices violating Fourth and Fifth Amendments, treating the people guilty till proven, till proven is still all unconstitutional. Court using military. It's not military style tribunal tactics. Even in a military tribunal, you have to have the evidence to support the claims. You just don't have, in a military tribunal, you don't have like on these at regular courts here, you don't get to say, well, they violated my rights. No, we're in the military. It's about the facts. We don't care. Oh, and it was Melania's birthday. Crazy. Right, James? More of that central casting. And for those of you that caught last week's Monday, if you didn't, I highly recommend you go back because I have somewhat explained what's really going on with Iran. So, it's the takedown of Islam as a religion and Sharia law, because they've infiltrated the government over there. They've hijacked the government. But over here, we've known that for a very long time. Okay? I mean, they found their plans, from 1983, and then again in 1991. And they were pretty close here. Right, prayer warrior. King Charles, literally the Walking Dead. Exactly. Central casting. But, oh, hey, Doug. Good to see you. Oh, it's worse than just Wizard of Oz, brother. Right? You can't handle the truth, Genevieve. I hear military tribunals. Hey, Bobby Hall, quick and faster than Fix It Fast. Just heard the military brought back death by firing squad. Well, that was done back in 2019 when Trump amended the manual. Actually, no, that was in 2018. My bad. It became effective January 1st, 2019. Made amendments to the manual for courts martial, which the last time that was amended was 1984. Imagine that. But here in Idaho, last year said death by firing squad, and they built stuff. I need to go out there and check it out. But we're going to start doing death by firing squad here in Idaho. Yeah, buddy. Right? Munson, 58. You have entered into the Twilight Zone. Oh, yeah. Things are going to get real soon on a local level. And I keep saying this. By July 4th, it's liberation time, folks. You want to see the complete renovation of the ballroom? Yeah. It died from lead poisoning, right? Wouldn't have anything to do with the lead holes or the holes in their body created by the lead. But, yeah. Yeah. There you go, James. Central casting is they're all actors in DC. It's a fake government movie. That's what I thought too, James. Ballroom, Baal. But I don't think that's what Trump means. But anywho, it's all being played out. This has already happened. Right back to Texas v. White, pursuant to Article 4, Section 4, the president, only acting as commander-in-chief, has the power to set up provisional government pending the outcome of the war. We're at war. I don't know how better to explain it than Executive Order 13818. Those involved in serious human rights abuse and corruption worldwide. December 20th of 2017. Right after that executive order, he went over to Saudi Arabia because that's what was in that executive order specifically about Saudi Arabia. And named names of who it was to go to take down the corrupt governmental regime in Saudi Arabia. So, this stuff has already happened. So, at some point in time, the real truth is going to come out. Okay? Yeah, there is the Executive Order 13848, those involved in foreign interference in a federal election. That one there is not the main one. The main one is the 13818, which James can just posted there on Rumble. Both are significant, but the number one is the 13818, which is the one that Derek Johnson missed. He was going off the 13848. He missed the 13818, the one that involves the entire world, and that has to directly do with corrupt governmental regimes. That executive order is about taking down corrupt governmental regimes, instituting new government, holding elections, and then doing a treaty of peace. And yeah, the whole Executive Order 13848 about foreign interference in U.S. elections stuff, the truth, evidence is coming out on that. It's been out for many years, and I don't understand how anyone at this point can't know that there was some fraudulent stuff going on in these elections. So, you know, that was a big thing, especially for strikes on YouTube and stuff about talking about election fraud and all this stuff. Genevieve, Tennessee just passed the law that residents have the right to use deadly force to stop theft of property. What is the definition of property again? Property is actually, the first definition is an aggregate of guaranteed rights. But see, there again, Tennessee just passed a law. That's not a law, it's a statute. It's already the law. It comes from the laws of nature. You have the right to acquire, possess, right? And utilize our private property how we see fit. That's from the laws of nature. But for those that don't quite comprehend the law, It's look for this in your Tennessee Constitution here. Inalienable rights of man. All men are by nature free and equal, and by nature. And, so this is still nature, and have certain inalienable rights, among which are enjoying and defending life and liberty. Enjoying and defending life and liberty. Acquiring, possessing, and protecting property. Protecting. That's defending, protecting. Pursuing happiness and securing safety. Uh-oh. So this totally destroys their whole argument about, well, it's for your own safety. No, 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 no. That's a power retained by the people. We didn't delegate that power to you. That's part of the laws of nature. We get to secure our own safety, which is why we all have the right to keep and bear arms, which shall not be infringed. Uh-oh. So this is the thing, is, this just is prima facie evidence that they've all been brainwashed and indoctrinated because they think they need to make a law for that. Well, Tennessee just made a law that says you can defend, use deadly force to protect your property. It's already the law. But see, they're so brainwashed and indoctrinated to believe that, well, they are the ones that make the law. But if any man were to simply read this, in fact, here, let's just do this. Let's just do Tennessee. Let's see. Okay, why is this not taking me to the actual Constitution? Tennessee State Constitution. Man, am I missing something here? I don't know about that one. Let's go with this. Okay, there we go. Let's see. That's, yeah, I'm not. That the citizens of the state have a right to keep and bear arms for their common defense. Huh. Wow, the General Assembly shall make no law recognizing the right of property in man. Whoops. Yeah, I don't really see exactly um, the same verbiage that's in Idaho, but anywho, it's a basic right, right? The right of self-defense to defend our property. Um, life, liberty, and property. We have the right to defend that. But it doesn't matter because right here, it says the same thing over here. This is a Declaration of Rights. Everybody has these same rights, right? Because these come from nature. That's that life, liberty, and property, which Blackstone elucidates in his commentaries. Personal liberty, well, first it's personal security, personal liberty, and then private property. That's that life, liberty, and property. There's also free will, right? That's the first part of it. Ooh, excuse me. Oh, a Munson. You're showing your age. ACDC, big balls. I've got big balls. She's got big balls, but I've got the biggest balls of them all. Oh, yes. But yeah, no, we know that, Doug. But the thing is we're kind of getting specific with the right of defending your property and using deadly force. It used to be well known that if you trespassed on a man's property, he had every right to shoot you. Period. It used to be state your name and state your business. Well, I'm so and so, get off my property. If they didn't leave, you could shoot them. Period. You have the right to defend your property. But we've all been dumbed down and led to believe and turned into criminals, right? That if you can't do that. You have to call somebody in authority,
to make that decision now. Now. We call the sheriff for the ones that got away, and we call the coroner for the ones that didn't. That's the way that's supposed to work. Oh, that's a good one, Genevieve. Chestnuts or chess balls. Yep. Right, I get that every state is subject to the federal constitution. But what we're talking about here is the common law and the laws of nature. Plain and simple. That comes before the Constitution. Constitutions are the instrument of government. That's not the common, I mean, it's part of the common law, but it's not the common law and it's not the laws of nature. Remember, the government is instituted to secure these rights. Government is instituted. The Constitution is the institution of government, the instrument of government. So the laws of nature and the common law has to pre-exist the Constitution in order for the Constitution, instrument of government, to secure these rights. Right? Speaking logically, the one has to pre-exist the other for it to even make sense. Right? I mean, that is ultimately in the preamble. And remember, the states came before the federal Constitution. Uh-oh. That's right. But this is one thing that's important about the preamble. Because the preamble is the intent. We, the people of the state of Idaho, grateful to Almighty God for our freedom, to secure its blessings and promote our common welfare, do establish this Constitution. Now let me translate this. To secure our God-given rights, we do hereby create government. That's what that says in layman's terms. But the thing is, our form of government was already created prior to the federal Constitution. That's right. It's called the Virginia Constitution of June 29th, 1776. With the 3 distinct branches of government. That is the original first Constitution. Go watch my episode 1 in my free educational series on YouTube. Okay? That will explain to you, as I've already laid all the proof, the evidence, that there are 4 documents that go together. You got the Lee's Resolution, you got the Virginia Declaration of Rights, June 12th, 1776, the Virginia Constitution, June 29th, 1776, and then you have the Declaration of Independence, July 4th, 1776. Those 4 things go together. It's not just the Declaration of Independence. Wow. Yeah, I don't want to get into that right now, Wendy, but interesting. Yeah, that'll be shut down, I'm sure. Yeah, and a shortage of good rope, huh, Michael Casper? Uh, yep, Diesel D's. The only reason firing squads are being brought back is because there will be a huge increase in executions. Now, I'll be honest. The reason why I think the reason why, aside from the fact that there's going to be lots of executions, granted, is to instill the fear of criminals into, or potential would-be criminals, that, oh crap, you might get executed, death by firing squad. Not to spend a little bit of slap on the wrist and spend some time in jail, prison. No. No, 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 no. No, Doug, we are the sovereign. The people are the sovereign. Okay, what sovereign is creator. I agree that God is the sovereign as he created everything. He created mankind. So his laws of nature, are the law. But when you're talking about the word sovereign as in related to creating the instrument of government, those who create are the sovereign. Thanks, Dreaming Deer. Good to see you. Good night. The thing is just like a mother and father is sovereign over their sons and daughters because they created their son and daughters. So government is invested with sovereignty, but we are the sovereign because we created government and we have all of the power. 10th Amendment. So that's how that works. And again, the true meaning of sovereign is the power to create. So, if I build something out here, I created that. I am the sovereign over what I create. Like a business. Okay? No man has a higher authority over my business than me. None. None whatsoever. Now, there are certain policies and regulations that go along with running certain types of businesses. But when we're in the private, it's none of government's business because if we're not acting in foreign, interstate, or even intra-state commerce, they don't have the power to regulate that. So, right, James? Yeah, I'm just going to leave that one alone. But that's how that happens, right, James? Procreation. And per the laws of nature, God gave us the attraction of the sexes. There's only two sexes, man and womb man with a womb. Naturally, fundamentally and principally, we're supposed to be attracted to one another. But again, that's part of Sodom and Gomorrah. It's the sexual immorality, right? And This is part of Saul Alinsky's rules for radicals to take over the education. Da 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 da. It's just a big master plan to dumb down society. And then you got to add in all of the other chemicals. Some are injected, some are consumed. Whether it's in our food, water, in the air, at the office, the other office. Yeah, I mean, we're flat out being poisoned. And it's altering our DNA. And then you start them off at a young age, screwing their minds up, thinking that they can change their gender when there's no such thing as gender. It's sex. Man or woman. That's it. There's no other sexes. Now I'm well aware of hermaphrodites. But the question is do they have a womb? Yeah. Yeah, that would be a good one too, Munson. Bring back tarring and feathering. But I think death by firing squad is quite the deterrent. Yeah, I think it's quite the deterrent that, oh crap, if we're involved in this, we might be executed and it'll be death by firing squad. This is what needs to come back, is holding people responsible. That's not accountable. It has to do with accounting. Responsible is holding them responsible for their actions. So I think that's what's coming back. And the law, as we can see, there's a lot of stuff changing. So justice is coming. It's coming, folks. It's taken, it's taken a long time to get here where we're at. To how corrupt things are. Worldwide, right? This isn't just America. Trust me, it's not just America. In fact, a lot of other places are much worse than we are here in America. And the main reason is because we still have the right to keep and bear arms. Even though they've tried so hard to strip us of that right, and finding different ways to strip the people, as many as they could possibly can, by turning people into felons, criminals. So it's time to start holding these corrupt individuals responsible. And some of them are going to be put to death by firing squad. That's the law. I'm going to talk about, we've got to make a law for that. Alright, folks. On that note, death by firing squad, Executive Order 13818. Welcome to the real world where justice and rights are being upheld. I hope you all enjoyed tonight's show, and Have a wonderful night, and we'll see you next week. God bless. Much love. Good night, everybody.